Okay, since there's the government shutdown, I'm gonna do a little free advertisement for a government agency. You know, they're probably still getting paid, but this is really need to know. This is for the Attorney Registration and Disciplinary Commission and the Judicial Inquiry Board. Do you ever want to kick a lawyer in the nuts and make sure they don't ever work again? You go here and you file charges. I'm going to explain to you how. You ever see a judge make some crazy decision or give somebody preferential treatment? You know, well, when they favor somebody over another, then you go to the Judicial Inquiry Board. These are some big guns, okay? Now, what I'm going to teach you, don't go to court with these guns. No, that's just going to Dodge and having a shootout. These are meant to fire from a distance, far, far, far away. It's a sure shot. It's like a laser-guided missile. Okay, these are weapons of mass destruction. Seriously, they're protesting out in the streets and all that stuff about laws and due process. I guarantee you, none of you know what due process is. I've been trying to teach people this since the early '80s, and I've reached a few people, helped a few people. I always told myself when I started this, if I could just reach one person. Okay, now this is my opportunity to reach a lot of people. I want to teach you what due process is and what it isn't. Okay, and so far all you know is what it isn't, but you feel like there's nothing you can do about it. And I've been teaching some people, but they're doing it wrong. So I'm going to do exactly what I tell you. Do exactly what I tell you. Within 2 weeks, you'll hear something from these people. The ARDC, Attorney Registration and Disciplinary Commission. Okay, every state has one. There's a federal version as well, and they're supposed to make sure that the judge follows the rules. Your lawyer, the opposing lawyers, so on and so forth. There's a whole lot of rules that they got to follow, and they aren't very hard or long. At most, they're like a paragraph. But I just want to take you through it because a lot of people keep asking me how you get this stuff done and do this, and it's just that I know rules and I know nobody plays by them. So, but you'll understand as we go through it. Okay, I see here. This is the ARDC. Sorry, I can't zoom in, and there's something in there about Trump. Let me just go there. That's the internet for you. Okay. The ARDC, Attorney Registration Disciplinary Commission. The Supreme Court established the ARDC as an administrative agency effective February 1st, 1973, in charge with assisting the court in the regulation of legal profession in Illinois. Okay, so that basically tells you where it started. But I'm going to cut to the chase, and we're going to go to rules and decisions, okay? Rules and decisions here, people. Okay? Disciplinary reports and decisions. Sure. So if you want to look up a lawyer and see if he or she is or isn't doing what they're supposed to, you want to come here and look up rules and decisions, see if somebody's filed a court a complaint against them. Okay, rules governing lawyers and judges. That's where we're going, okay? Okay, see, now look at right here they have the Illinois Code of Judicial Conduct. But first I'm going to go over the Illinois Rules of Professional Conduct, okay? So we'll click on that, Rules of Professional Conduct. Let's go to terminology first, okay? There's one thing people fail to understand is some of the terminology. Belief or believes, confirmed in writing, firm or law firm, fraud, knowingly, partner, reasonable belief. See, these are okay, we'll go beyond that. Okay, we'll go 1.1. I'll just go try to skim through them as quick as I can. A lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. Okay, legal knowledge and skill, you can go through that yourself. But this is right here, thoroughness and preparation. Competent handling of particular matter includes inquiry into analysis of a factual and legal elements of a problem and use of methods and procedures in meeting the standards of competent practitioners. This also includes adequate preparation. I always found multiple continuances in violation of that. We don't have this. We don't have that. Well, walk your ass over there and get it, you dumbass. The required attention and preparation. Okay, we'll bypass that. Scope of representation, allocation of authority between client and lawyer. Okay, subjects to paragraph. Oh, okay, so it says a lawyer shall abide by a client's decision concerning objectives of representation and as required by Rule 1.4 shall consult with the client as to means by which they are to be pursued. So they got to ask you before they do anything. The lawyer may take such action on behalf of the client and is repeatedly authorized to carry out representation. A lawyer shall abide by a client's decision whether to settle a matter. In a criminal case, lawyer shall abide by the client's decision after consultation with a lawyer as to a plea entered, whether waive jury trial, or whether a client will testify. A lawyer's representation, B. A lawyer's representation, that's 1.2b. A lawyer's representation of a client, including representation by appointment, does not constitute endorsement of client's political, economical, social, or moral views and activities. A lawyer may limit the scope of representation if the limitation is reasonable under circumstances. A lawyer shall not console a client to engage or assist the client in conduct that the lawyer knows criminal or fraudulent. Discuss legal consequences of any proposed course of conduct with the client. Counsel may assist the client to make good faith effort to determine the validity, scope, meaning, or application of the law. The counsel to assist the client in conduct expressly permitted by law. Okay, you'll understand more as I go on. Okay, okay, this is a rule I always found. Every lawyer violates this. Diligence. A lawyer shall act with reasonable diligence and promptness in representing a client. And the comments here, it gives you things, basically, they should or shouldn't do. Lawyers should pursue a matter on behalf of a client despite opposition, obstruction, or personal inconvenience to the lawyer, and take whatever lawful and ethical measures required to vindicate a client's cause or endeavor. A lawyer must also act with commitment and dedication to the interests of the client with zeal and advocacy upon the client's behalf. A lawyer is not bound, however, to press for every advantage that might be realized for a client. For example, a lawyer may have authority to excuse professional discretion in determining the means by which a matter should be pursued. A lawyer's duty to act with reasonable diligence does not require the use of offensive tactics to preclude the treating of all persons involved in the legal process with courtesy and respect. A lawyer's workload must be controlled so that each matter can be handled competently. Perhaps no professional shortcoming is more widely resented than procrastination. Anybody know what that means, procrastination? A client's interest often can be adversely affected by the passage of time or change of conditions in extreme instances. As when a lawyer overlooks a statute of limitations, the client's legal position may be destroyed, even when the client's interests are not affected in substance. However, unreasonable delay can cause a client needless anxiety and an undetermined
confidence in the lawyer's trustworthiness. A lawyer's duty to act with reasonable promptness, however, does not preclude the lawyer from agreeing to reasonable requests for postponement that will not prejudice the lawyer's client, unless the relationship is terminated by provided by Rule 1.6. The lawyer shall carry through to conclusions of all matter undertaken by a client. If a lawyer is employed is limited to a specific matter, the relationship terminates when the matter has been resolved. Okay, communication. I have yet to meet a lawyer that does this. Rule 1.4, communication. The lawyer shall promptly inform the client of any decisions, circumstances with respect to the client's informed consent. So understand this, people, without the informed consent, without you even knowing the ARDC exists, without your lawyer telling you this, all this exists, is a violation of your constitutional rights. Due process is knowing this. And I will continue. You'll see more. Communication with the client, reasonable communication with necessary to effectively to participate in representation. Okay, reasonable communication between the lawyer and the client is necessary for the client effectively to participate in the representation. Okay, communicating with the client. If these rules require a particular decision about the representation may be by the client, requires that the lawyer promptly consult with and secure the client's consent prior to taking action, unless prior discussions with the client has resolved the action the client wants the lawyer to take. For example, a lawyer receives from opposing counsel an offer of settlement in a civil controversy of a preferred plea bargain in a criminal case must promptly inform the client of its substance unless the client has previously indicated the proposal will be acceptable or unacceptable, or has authorized the lawyer to accept or reject the offer. So they can't make any decisions without you. And it has to be an informed decision. Okay? I had a lawyer settle with an arbitrator, and I told him, no, nothing goes on without me there. But see, this is where we get back at them. Okay, explaining matters. The client should have sufficient information to participate intelligently in decisions concerning the objectives of representation and by the means which they are to be pursued, to the extent that the client is willing and able to do so. Adequacy of communication depends in part on the kind of advice or assistance that is involved. For example, when there is time to explain a proposal made in negotiation, a lawyer shall review all important provisions with the client before proceeding to an agreement. In litigation, a lawyer should explain the general strategy and prospects of success, and ordinarily should consult the client on tactics that are likely to result in significant expense or to injure or coerce others. On the other hand, a lawyer ordinarily will not be expected to describe trial or negotiation strategy in detail. The guiding principles of lawyers should fulfill reasonable client expectations for information consistent with the duty to act in the client's best interest. The client's overall requirements as to the character of representation. In certain circumstances, such when a lawyer asks the client to consent to representation affected by conflict of interest, the client must give informed consent. Okay, ordinarily information to be provided is appropriate for a client who is comprehending and responsible adult. However, fully informing the client according to standard may be impeccable. For example, when the client is a child and suffers from diminished capacity. Okay. Withholding information in some circumstances, the lawyer may be justified in delaying transmission of information when the client would be likely to react impunitively or in immediate communication. Thus, a lawyer might withhold a psychiatric diagnosis of the client when the examining psychiatrist indicates a disclosure would harm the client. The lawyer may not withhold information to serve the lawyer's own interest or convenience or convenience of another person. rules or court orders governing litigation may provide the information supplied to a lawyer. Okay, fees. You want to go over that yourself. I just want to get to the ones that I feel are going to help right away. Confidentiality of information. Or the lawyer shall not reveal information relating to representation of the client unless the client gives informed consent. The disclosure is immediately authorized in order to carry out the representation or disclosures permitted in paragraph B or required by paragraph C. A lawyer may reveal information relating to a representative client to extend the lawyer's reason believes necessary. To prevent a client from committing a crime, to prevent a client from committing fraud, to prevent, mitigate, or rectify substantial injury. So basically, he's there to tell you what you can do legally and what's illegal, and to advise you not to stay away from. So you make all the decisions. He just it tells you in here. The legal term for a lawyer is assistance of counsel. He's there to assist you and guide you through the legalities. He's not there to make the decisions for you. You are the conductor. The lawyer, state's attorney, the judge, they are the orchestra. Okay? But you'll learn that as we read on. Okay, disclosure, adverse to the client. Although the public interest is usually best served by strict rule requiring lawyers to preserve the confidentiality of information related to representation of the clients, we'll bypass that. Okay. Okay. Now, this is what you really need to know. Informed consent. Informed consent that requires that each affected client be aware of relevant circumstances and of the material and reasonably foreseeable ways that the conflict would have adverse effects on the interests of the client. See Rule 1.0E, informed consent. The information required depends on the nature of the conflict and the nature of the risk involved in representation. Multiple clients in a single matter is undertaken. The information must include the implications of common representation, including possible effects on loyalty, confidentiality, and attorney-client privilege, and the advantages and risks involved. Okay, so you can go on with informed consent, but there's certain rules that I've been trying to get these people to understand. And like I said, they violate anything here, and it's all over for them. You get a new start, they'll be lucky if they get a job serving fries. Okay. Okay, I know a lot of people are going to want to see that with special conflicts of interest and for former and current government officers and employees. Okay, former judge, arbitrator, organization as a client. Client with diminished capacity, safekeeping property. See, they got a lot of rules what they can and can't do. So you ever feel like you've been screwed over on some property, some money? Just check these rules. You can't get the money back from because they won't give it to you. Well, when you file against them, they'll come with you with NDA, non-disclosure agreement. Declining or terminating representation, which it's impossible for them to do. Except as stated in paragraph, a lawyer shall not represent a client while representation has commenced, shall withdraw from representation of a client if representation will result in violation of rules of professional conduct or the law. lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client, or the lawyer is discharged. So just think of that. When you file charges, they get discharged and they can't do this shit to anybody anymore. Withdrawal can be accomplished without material adverse effect of interest. Okay. Discharge option. Oh, if anybody, you're looking for a lawyer, remember this one. Duties to prospective client. Okay, a person who consults with a lawyer about the possibility of forming a client-lawyer relationship with respect to the matter and his prospective client. Even when no client-lawyer relationships, the lawyer who has learned the information from prospective client shall not use to reveal that information. Okay, so okay, Rule 2.1, advisor representing client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, a lawyer may refer not only to law but other considerations such as moral, economic, social, political factors. Okay, meritorious claims and contentions. A lawyer shall not bring or defend a proceeding or assist or convert as issue therein unless there is a basis of law of fact for doing so that is not frivolous, which includes good faith argument for an extension, modification, or reversal of an existing law. A lawyer for a defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may nevertheless so defend the proceeding as required that every element of the case established. Okay, so basically that just says you can't be convicted on hearsay. Okay, but they have comments here. The advocate has duty to use legal procedure for the fullest benefits of the client's cause, but also duty to not to abuse legal procedure. The law, both procedural and substantive, establishes the limit within the advocate may proceed. However, the law is not always clear and never static. Accordingly, in determining the proper scope of advocacy, account must be taken laws, ambiguities, and potential for change. Sorry, I need to get something to drink. Expediting litigation. Now, this is important because who does this? Rule 3.2, expediting litigation. A lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. Now, when a lawyer shows up in the court for you, after you secured him as your counsel, assistance of counsel, when he shows up to court on your first court date, he should have everything. I mean, it makes no sense coming to court unprepared. So he should have discovery. So before he ever goes to court, as soon as he picks you up as a client, it'd be pretty quick, fast, and easy if he just walked over there and asked the other lawyer, hey, let me get the file, here's what I got, here's what you got, boom, boom. I've seen judges get mad and have people go in the back, make copies, and give it to clients because nobody else would. But see, all these people have to do is file charges, and they don't work no more. And they always violate these one way or another. I'm hoping my quick run through will give you some inspiration to get a lawyer fired, remove a judge from the bench. A lawyer shall not unlawfully obstruct another's party access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not console, assist another person to do any such act. B. Falsify evidence, console or assist a witness to testify falsely. Oh man, they do that a lot. Or offer an indictment to a witness that is prohibited by law. Knowingly disobey an obligation under the rules of a tribunal except for an open refusal based on assertion that no valid obligation exists. In pretrial procedure, make frivolous discovery request or fail to make reasonably diligent effort to comply with a legally proper discovery request by opposing party. You know what discovery is? File, whatever's in the file. Sometimes they call discovery facts discovery. So when your lawyer comes to court, state's attorney comes, whoever comes to court, that first time they're supposed to have discovery. Why don't they come to work prepared? So, but you know what? I'm going to show you where to get the form, where to go, and you're going to cite these rules, and you're going to ask the ARDC, how come they're still working here? Because they're not doing this. So, oh man, this is going to be fun. I feel good spreading this information. Okay, fairness to the opposing party. Falsify. Okay. So falsify evidence, console or assist a witness to testify falsely, or offer an inducement to a witness that is prohibited by law. You can't bribe anybody. Knowingly disobey an obligation under the law. Okay. And pretrial procedure, make a frivolous discovery request to fail, make reasonably diligent effort to comply with legally proper discovery request by opposing party. Like let's say there's a dash cam video. That's discovery. That goes in discovery. So, any evidence available, that goes in discovery. So if you don't get the video, the recordings in the police station, the interrogation, you don't get any of that stuff. This is the violation right here, Rule 3.4, fairness to opposing party and counsel. You're the opposing party, and counsel is your assistant. Your assistant's a counsel, your lawyer. Okay, remember that. He's your assistant of counsel. He's there to console you on legalities. He's not there to conduct it. You're the conductor. He is part of the orchestra, okay? Okay, request a person other than a client to refrain from voluntarily giving relevant information to another party unless the person is a relative or an employee of an agent or a client. The lawyer reasonably believes that the person's interests will not be adversely affected by refraining from giving such information. And then there's comments where they explain the procedure of adversary system contemplates the evidence in the case to be marshaled competitively by contending parties. Fair competition and adversary system, yada yada. You can come back. I'll come back at it, which I'm going to keep coming back at you and advertising for these guys because with the government shut down, and these guys don't advertise anyways. I hope you can see it. My vision is really, really bad. That's why I went to this extreme to do this. Oh, Rule 3.5, impartiality and decorum of the tribunal. A lawyer shall not seek to influence a judge, juror, prospective juror, or other official by means prohibited by law. Communicate ex parte with such a person during proceedings. Communicate with the juror. Communication is forbidden by law or court order. The juror has made known that to a lawyer desire not to communicate. Communication involves misrepresentation, coercion, duress, or harassment. Yeah, how many times a lawyer ever contact you without you having assistance of counsel? You know, in every legal matter, you have a right to assistance of counsel. And when a lawyer approaches you, he's supposed to ask you and engage with your assistant, not you. That serves as harassment. And when they make those feeble little threats, well, I'm a lawyer. You know what I can do to you? Well, here's what you can do to them. Okay? Many forms of improper influence upon a tribunal are permitted by criminal law. Others are specified in Illinois Code of Judicial Conduct. We're going to get to that. That's really good. Okay? I love that. Okay, now this one, everybody breaks this rule. It always pisses me off. I always see people break it. It's always on the news. A lawyer who's participating or who has participated in investigation or litigation of a matter shall not make extrajudicial statement that the lawyer knows or reasonably should know would be disseminated by the means of public communication and will pose a serious and imminent threat to the fairness of the adjudicative proceeding in the matter. So all these just put it this way: somebody gets arrested, they get shot or whatever, and they start throwing out there, well, he was arrested this many times, he was in prison for so many years, so on and so forth. What a lawyer won't tell you is those matters are preserved for sentencing issues only. You can ask them. So anything mentioning that anytime before that is trial court publicity. That's meant to sway a judge or a potential jury. But maybe that's why they use the excuse why they won't let dash cams out there, because nobody wants to see what really happened, do they? Okay, so that's trial court publicity. Notwithstanding, lawyer may state the claim, offense, or defense involved, except when prohibited by law, the identities of the persons involved. The information contained in public record. That the investigation of matters in progress, the scheduling and result in any step in litigation, the request for assistance in obtaining evidence and information necessary thereto, warning of a danger concerning the behavior of a person involved, whether there is reason to believe that there exists a likelihood of substantial harm to the individual or public of interest. The criminal case addition. Paragraphs 1 through 6, the identity, residence, occupation, family status of the accused. If the accused has not been apprehended, information necessary to apprehend that person. Okay, so there's a lot of do's and don'ts in here, and they don't do a lot of do's and don't. Just okay. Special response. Now this one always gets me. Special responsibilities of a prosecutor. Now, if I was running as a state's attorney, especially you new kids, young people, I'm old. My time is near coming to an end. So somebody's got to, get out there and do this, okay? Make sure they follow through on this, because they don't. The state's attorney always violates this rule. So if I, whoever out there is going to run for state's attorney next, this is what I want to hear. This is what I want to hear when you put out your little campaign speeches. The duty of the public prosecutor is to seek justice, not merely to convict. The prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Why do they always avoid the probable cause hearing? The public defenders always try to bypass the probable cause hearing. You know why? Because then they keep coming in there to court and asking for continuances. Seriously, as soon as you go to court, first day, you want a probable cause hearing. And if you have to ask the questions yourself, do it. I can guarantee the public defender will do as little as possible. You walk in there and say, hey, just sign this and you can go. You ain't got to come back. Next thing you know it, you get pulled over and, the cops are telling you you got a felony conviction. So no, you don't want no conviction. All right. First, a probable cause hearing. All right. Demand it. It's your right. It says right here. Refrain from prosecuting a charge that a prosecutor knows is not supported by probable cause. Make reasonable efforts to assure that the accused has been advised of the right to and the procedure for obtaining counsel and has been given a reasonable opportunity to obtain counsel. Not seek to obtain from an unrepresented accused a waiver or important pretrial rights, such as the right to a preliminary hearing. Okay, I've seen that happen so many times. So it says right here, special responsibilities of prosecutor. You know anybody sitting in county lockup that waive their right? It says here, not to obtain from an unrepresented accused a waiver of important pretrial rights, such as the right to a preliminary hearing. Make timely disclosure. Disclosure is the file, everything that they're going to use against you. That's disclosure. If there's videotapes, confessions, whatever, everything has to be there. And they should have it day one when they walk in. Make timely disclosure of defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense and or a connection with sentencing, disclosure to defense or tribunal, all unprivileged mitigating information known as a prosecutor, except when the prosecutor is relieved from the responsibility by protective order of the tribunal. Not to subpoena a lawyer in a grand jury or other criminal proceedings to present evidence about a past or present client unless the prosecutor reasonably believes the information sought is not protected from disclosure by any applicable privilege. The evidence sought is essential to successful completion of ongoing investigation and prosecution. There's no feasible alternative to obtain the information except for the statements that are necessary to inform the public of the nature of the extent of the prosecutor's action and serve as legitimate law enforcement purpose. Refrain from making extrajudicial comments. That pose a serious imminent threat to heightening public condemnation of the accused and exercise reasonable care to prevent investigators, law enforcement personnel, employees of other persons assisting or associated with the prosecutor in criminal case from making extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 of this rule. People, please read this. When a prosecutor knows a credible material evidence creating a reasonable likelihood the convicted defendant did not commit an offense for which the defendant was convicted, the prosecutor shall. This is what I want to hear the next guy or woman. Hopefully it's a millennial, because I know they'll carry this out. When a prosecutor knows credible material evidence creating a reasonable likelihood the convicted defendant did not commit the offense to which the defendant was convicted, the prosecutor shall properly disclose that evidence to an appropriate court or authority. And if the conviction was obtained in the prosecutor's jurisdiction, properly disclose the evidence to the defendant unless the court authorizes a delay, and undertake further responsibility investigation or make reasonable efforts to cause an investigation to determine whether the defendant was convicted of an offense the defendant did commit. When a prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense the defendant did not commit, the prosecutor shall seek remedy The conviction. I, a prosecutor's judgment made in good faith that evidence does not rise to standards stated in paragraphs G or H through subsequently determined to have been erroneous, does not constitute a violation of this rule. Can you remember that? Rule 3.8, special responsibilities of the prosecutor, of a prosecutor, of a prosecutor. Advocate in a non-adjudicative proceedings. Don't trust them. I've been through with them. They get mad at me every time and they lose every time. Truthfulness and statements to others. See, now they're required to be honest with you. Make a false statement or material fact to law to a third person. Failure to disclose material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless otherwise disclosed. So this doesn't mean just his client. That means if he does it or if he knows the public defender is doing it, it's the prosecutor's job to make sure that your lawyer follows all these rules. It's the judge's job to make sure nobody violates these rules, that everything is followed to the letter. Okay. Misrepresentation. Okay, statement of fact. The rule refers to statements of fact as well as law. Whether a particular statement should be regarded as one of fact can depend on circumstances. After they convict you and they want to send you off, they send off this thing, statement of facts, to unbash you, make you look as bad as they possibly can, and they always embellish on it. So their statement of facts is more like a stack of shit. Under generally accepted conventions and negotiations, certain types of statements partly are not taken as statements of material fact. Estimates of the price and value placed on a subject transaction to a party's intentions. Acceptable settlement of claim ordinary in this category. Crime or fraud by a client. I can't count how many times I've witnessed people commit fraud. Communication with person represented by counsel. In representing a client, a lawyer shall not communicate about the subject of representation with the person a lawyer knows to be represented by another lawyer in a matter, unless the lawyer has consent of the other lawyer or authorized to do so by a court order. Dealing with an unrepresented person, this rule is violated continuously. In dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. When the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, a lawyer shall make reasonable efforts to correct the misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than advice to secure counsel. If the lawyer knows or reasonably should know that the interests of such person are or have a reasonable possibility of being a conflict of interest with the client. So if a lawyer approaches you, knows you don't have an attorney, the best he can do is tell you you need to get an attorney. Other than that, it just falls under harassment. And they do harass a lot of people. You know what I could do to you? I always tell them, sue me. I don't want to do that. I want you to. You never do. But then I start throwing all this stuff out. Responsibilities of partners, managers, and supervisory lawyers. So that means if you're a county and you got a PD, and he violates these rules, guess what? Their boss gets held responsible. Just as they're held responsible. They knew or they should have known. It's their job. It's their job to know. If they didn't know, it's because they were being lazy and didn't give a fuck. Excuse my language. They didn't care. Okay. So, and the state's attorney as well. So if a state's attorney violates any of these rules, then the supervisor gets held responsible as to. Okay, so don't let them tell you, oh, well, we didn't know or we weren't aware. It's their job to know. Okay, you could read about a lawyer having direct supervisory authority over another lawyer. Shall make reasonable efforts to ensure that that lawyer conforms to the rules of professional conduct. And then there's more saying that they have to conform to these rules. Responsibility of a subordinate lawyer. Lawyer is bound by the rules of professional conduct, notwithstanding the lawyer acted in the direction of another person. The lawyer does not violate the rules of professional conduct if the lawyer acts in accordance with the supervisor's lawyer's reasonableness resolution of an arguable question of professional duty. So sometimes, yeah, lawyers do what their bosses tell them to do, even though they know it's a violation of these rules, which is a violation of due process. You know, so people really need to know what due process is. And this is it. I'm trying to go over it as quick as possible. Responsibilities regarding non-lawyer assistance, professional independence. There's more. I can't see that good. These headaches, they blur my vision. My vision's been pretty shit for years. So I had to go to this extreme just to see what I can. Oh. Okay, judicial and legal officials, a lawyer shall not make a statement the lawyer knows to be false with the reckless regard as its truth to falsity concerning qualifications or integrity of a judge, a judiciary officer, or a legal officer, or a candidate for elected appointment council legal office. A lawyer who's candidate, that's good. Reporting professional misconduct. Okay, so if somebody doesn't abide by these rules, it's everybody's responsibility to report it. If the public defender doesn't abide by the rules, the state's attorney is supposed to report it to the ARDC, Attorney Registration Discipline Commission, and inform the judge. But the judge should know, because the judge knows these rules, and the judge is there to enforce these rules. If you don't enforce these rules, then the judge is to remove you from your position, file charges with the ARDC. I think the Bar Association as well. You know, they don't get to work as a lawyer no more. So everybody's supposed to be watching each other, you know, like I just say bird dogging each other. You know, once somebody makes a mistake, they're supposed to vamp on each other. So look at Rule 8.3, reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of Rule 8.4b or 8.4c shall inform appropriate professional authority. The lawyer knows that a judge has committed a violation of applicable rules of judicial conduct that raises substantial questions as the judge's fitness for office shall inform the appropriate authority, which is the Judicial Inquiry Report. This still rule does not require disclosure of information otherwise protected by attorney-client privilege or a law of information gained by a lawyer or judge while participating in approved lawyer's assistance program or intermediate program approved by circuit court non-disciplinary complaints against judges, lawyers be referred. A lawyer who has been disciplined as a result of a lawyer disciplinary action brought before anybody other than the Illinois Attorney Registration Disciplinary Commission shall report the fact to the commission. Okay, so reporting professional misconduct. Everybody is bound by this rule. The judge, the lawyers, everybody. And if they know and don't report it and you find out later, they wind up being one of the dominoes. You know what happens when you click over one of those dominoes and the others just start to fall? All you gotta do is hit that one. Everybody falls with them. Everybody. Everybody. Imagine that, closing down the PD's office, the public pretender's office, because they're a bunch of fakes. They're a bunch of everyone I come across. And we argued. They had me escorted out of the building one time because I was trying to teach people this. Okay. See, it's supposed to be, it says here, comment. Self-regulation in the legal profession requires that a member of the profession initiate disciplinary investigation when they know of a violation of the rules of professional conduct. And it shows you where to look. Lawyers have similar obligation with respect to judicial misconduct. An apparently isolated violation may indicate a pattern of misconduct that only a disciplinary investigation can uncover. Reporting a violation is especially important where the victim is unlikely to discover the offense. A report about misconduct is not required whether it be involved disclosure of information protected by attorney-client privilege or by the law. However, lawyers should encourage a client to consent to disclosure or prosecution, but not substantially prejudice the client's interest. If a lawyer were obligated to report every violation of the rules, the failure to report a violation would itself be a professional offense. I'll read it again. If a lawyer were obligated to report every violation of the rules, the failure to report any violation would itself be a professional offense. Such a requirement exists in many jurisdictions, but proved to be unenforceable. This rule limits the reporting obligation to those offenses that self-regulated profession must vigorously endeavor to prevent. A measure of judgment is therefore required in complying with the provisions of this rule. A report shall be made to the Illinois Attorney Registration Disciplinary Commission unless another agency is more appropriate in the circumstances. Then it tells you where to look. The duty to report professional misconduct does not apply to a lawyer retained to represent a lawyer with professional misconduct is the question, or a lawyer is consulted in a professional capacity by another lawyer. So on and on and on. Okay, so anytime somebody does something they're supposed to, everybody's supposed to tell on each other. Misconduct is a professional misconduct for a lawyer too. Attempt to violate the rules of professional conduct. Knowingly insist or induce another to do so, or to do so through the acts of another. B. Commit a criminal act that reflects adversely the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Engage in a conduct involving dishonesty, fraud, deceit, or misrepresentation. D. Engage in conduct that is prejudicial to the administration of justice. E. State or imply the inability to influence improperly government agency or officially achieve results by means violating the rules of professional conduct or other law. Knowingly assist a judge or a judicial officer in the conduct of violation of applicable rules of judicial conduct or other law. Nor shall a lawyer give, lend, or anything of value to a judge, official, or employee of a tribunal, except those gifts, loans that a judge or a member of the judge's family may receive through Rule 65C4 of the Illinois Code of Judicial Conduct. Okay, like I said, there's a lot of rules that they can't break. Find one and they're done. Okay, and they violate multiple rules in every circumstance. So if you got a lawyer, tell me what discovered. If you don't give it to you, then you refer to the rules. Don't even refer to the rules. Just file charges with the ARDC. Okay. He won't give you anything. Okay, I'm going to end this for now. I'm going to come back later. Okay. This is what helps me through the PTSD thing. The pills never help. The psychiatrists, they didn't want to talk about it. They didn't want to hear about it. And I try to tell them this is how I help people. And they think I'm some kind of nut. When I said legal advice, I didn't mean legal advice.
I just meant that they should know what due process is. And the last therapist I explained it to, now she don't want to talk to me because what I went through is because due process wasn't served. I was served, but it wasn't justice. But it was served by just us. Okay. So seriously, I'm gonna keep coming back at you. Go over specific rules. Do loose shorts and stuff. And I'm gonna advertise for the ARDC, Judicial Inquiry Board. Next, I'm gonna come back at you about the Judicial Inquiry Board. I need to take a shower and clean up. I'm sweating like crazy with the pain issues. I sweat a lot. And cluster migraines. That brings on another pain level. It gets bad. But teaching people this and how to get lawyers' livelihood taken away, get a judge's livelihood taken away. It's just that they're not following through with the filing of the charges. I'll show you how when I come back, okay? They're not following through with that. And they're just going to court, arguing with the judges and the lawyers. They shouldn't do that. They will get hurt bad. And when I come back to you, I'll show you what happened to me when I argued with the judges and the lawyers. Boy, that judge had the sheriffs take me from the court out to the woodshed. I'm lucky to be alive today. But I'll get back at you. This is PTSD in me. Saying good night. I'll catch you soon. Okay, this is what helps me get through what I have to get through every night. Knowing that I reached somebody. There's a lot of wrongful convictions, and this is how they get them. Okay, this is how they get the wrongful convictions. Okay. So seriously, we're going to go over this more and more and more. Remember, you have a right to discovery. Your lawyer will argue with your state's attorney, but make sure when you get up in front of the judge and the stenographer is typing away, because they won't want it to go on the record. But once you're in court, everything has to go on record. And all you have to do is tell, Your Honor, I want discovery, and my assistant here refuses to give it to me. Hey, state's attorney, special rules of prosecutor, fairness to the opposing party, and all that. Hey, can I get discovery? Mr. Public pretender over here won't give it to me. Ask Anna. Anna, when she brought up the rules, PD backed up, Your Honor, we're in a pickle. So I'm going to teach Anna how to take that pickle and stick it up their butt. Okay, kind of like this is going to be like a super-size suppository. Okay? Okay, but I'm going to keep coming back, keep coming back, keep coming back, This is the only way it helps, one of the many ways, but I've been doing this since the early 80s, trying to teach people, make copies, and be able to go to courts, and I got in a lot of trouble, got read. A lot of people thought I was nuts. But, now it's on the internet. You can see for yourself. Print out a copy. Highlight what matters to you. Go over it a couple of times. The most it takes is an hour long to read this, And, when they ask who sent you, who told you, tell them Pops did. My little boy asked me to be his dad. Gave me the name Pops. Thank you, baby boy. But it's not just my name, it's what I do. I protect our people, protect our peoples. I really need somebody else to start doing this because my time won't be long. I don't feel so good. And at least if I reach another person, it'll be worth it. What I've been through, what I went through, it'd have been worth it if I can stop it from happening to you. Good night, everybody. PTSD and me. This is what I do to cure it. Pills didn't help.